Now resume.
Thank you, Mr. Commissioner. The next witness is Lisa Miachka. If she could be affirmed, please.
You solemnly affirm that the evidence to be given by you through this hearing shall be the truth, the whole truth, and nothing but the truth?
Yes.
Would you state your name, please?
My name is Lisa Ann Miachka.
Thank you. Counsel.
Thank you. Ms. Miachka, I'll ask Mr. Lund to pull up number 52 from the exhibit list that Commission Counsel circulated. This, and indeed, is a substituted document or a redacted document. Ms. Miachka, you recognize that as being your resume or CV, is that right?
Yes, I do.
I'd ask that be marked as an exhibit, please.
Exhibit 582.
Thank you. And I'll do my best to summarize your background, and I'll ask a long question, but please correct anything I have wrong. In brief, I understand that you have been with the DFO since 1990. By way of background, you have a sociology degree from UBC, that you worked primarily with the DFO, first of all as a program analyst supporting the licensing policy and program development, and that in your time there you've worked in a number of different positions, and of relevance to commercial licensing that includes serving as the department's liaison officer for the Pacific Region License Appeal Board, or PR Lab, from the period of 1992 to 2000. Is that correct?
Yes, that's an accurate reflection of my background.
And furthermore, as Program Implementation Officer for the Pacific Fisheries Adjustment and Restructuring Program in the period of 1998 to 99, as Acting Chief of the Pacific Fishery License Unit in 2001-2002, and most recently in the range of 2009 to 2010, Acting Manager of Business and Client Services.
Correct.
And what is your current position, please?
My current position is Resource Manager of Pelagics.
Thank you. In terms of the in terms of how the department handles commercial licensing, which will be the focus of my questions today, and everyone's, I expect, I take it that the licensing is handled within the Pacific Fishery License Unit, and specifically the Business and Client Services branch?
Yes, the Pacific Fishery License Unit reports through Business and Client Services, and we have 3 offices, one in Vancouver, one in Nanaimo, and one in Prince Rupert.
And the branch that I was referring to itself is within Fisheries and Aquaculture Management?
Yes.
Thank you. Rather than asking you to provide an introductory lecture or a licensing 101 type of presentation, what I'll do my best in my questions to do is presume that we have some understanding of licensing through the Policy and Practice Report, or PPR. That document is part of the record here. It's been made an exhibit in these proceedings. So what I'll be trying to do is take you to some specific points. Having said that, what I would like to do at the outset is ask a few more general types of questions. First of all, it is said that the commercial salmon fishery is a limited entry fishery. Could you explain how that is the case and how licensing puts that into effect?
License limitation was introduced in the commercial salmon fishery in 1969, and what that meant is the department limited the number of licenses and participants in the fishery by implementing eligibility criteria that the vessels had to meet in order to be eligible for issuance of a license. I believe there was 5,870 licenses eligible at the time. What the department would have done is required entrusted participants or vessels to apply for the license, would review the applications on the basis of the eligibility criteria, and then inform those that were eligible and those that were ineligible for meeting that criteria. And accordingly, afterwards, we issued Category A salmon licenses and B licenses to eligible vessels.
And in terms of just in a layperson's understanding of a driver's license, or for that matter a recreational fishing license, where a person can walk up and apply and presumably receive, if they're entitled to it, they could receive that license. The commercial fishing licenses are not, their new licenses aren't simply created or issued on application. Rather, it's a question of renewing licenses to the vessels that have previously had them. Is that correct?
Yes, there's a record of all of the eligible vessels and the licenses that they hold in our licensing system. So we would keep track of all of the vessels, all of the fishermen, all of the data with respect to those vessels and fishermen and which eligibilities they hold, including salmon, and assign a number specific to each one of those licenses.
And if I were a commercial fishing vessel owner and fisher, and we're looking to continue salmon fishing, let's assume I have a commercial salmon fishing license, I'm looking to continue that, I take it that on an annual basis I would have to apply for renewal of my license?
Yes, there's a requirement in order to maintain eligibility for the license, you have to apply annually and submit the required license fee for issuance of the license. With salmon, the licensing year is April 1 to March 31st, so the requirement would need to be met by March 31st of that calendar year in order to maintain license eligibility.
And the license application, you mentioned the 3 office locations. I take it can be done at those locations. Are there other ways it can be done?
Applications can be submitted in the mail and or in person to any of those license offices.
What authorizations are required? Is it simply a matter of the vessel having a renewed license, or are there other authorizations or requirements that have to be met before, in my example, I head off again to fish salmon?
Well, the license officer that would receive the application would verify all of the information on the application. For example, with salmon licenses, they're held by vessels, so the vessel owner and who is the contact and representative for that vessel would have to be applying and sign the application in order for it to be approved. The fee would have to be submitted, and any other information with respect to designating, or in the case of salmon, vessel-based salmon licenses, they would have to submit to attach the license to the appropriate vessel, because the license is held by that vessel and it has to meet all of the requirements associated with that license, i.e. The right length, overall length for the vessel that they apply with.
Is there screening of the applicant? The person who comes forward to renew a commercial fishing license, does the department screen that by looking and for example, if there's a history or a problem of non-compliance with fishing regulations or difficulties in the past, is there any screening of the applicant?
No, when an applicant applies, the department looks with respect to the license. So whatever, we do have information in our licensing system on each license and vessel. Should there be any specific requirements associated with that license, the license officer would be made aware of that at the time that they review and verify the license application. But generally, we look at what's associated with that license in that particular year. We don't look at previous years or previous requirements unless there's something with respect to an estate and or seizure of a vessel or some extenuating situation.
And I'll ask you a question. The PPR is on screen, so I can perhaps use the document to do this. Page 19 of the report, Mr. Lunn, I expect will take us in the middle of the page to paragraph 51. And it's that paragraph I'll ask the question based on. I should add this, Ms. Miashka, I'll at the end of my questions, you'd offered some comments and clarifications and corrections about the PPR, and I'll try and hive those points off, and I'll ask you about those at the end all in one go. With respect to the comments here, the comment that's made in the PPR is that in practice, commercial salmon license suspensions do not occur. Similarly, DFO licensing staff do not consider Fisheries Act or license violations in renewing an annual license. Is that accurate?
Yes, the license officer is the delegated person based on the Minister of Fishery and Oceans Authority to review the application and issue it based on the requirements for that year.
And I take it there are other responses. the question of suspending or denying a license isn't the only tool in the toolbox, so to speak. There's an enforcement fisheries officer type of a response that is open to address the situation of a person with a bad track record of not following regulations, for example.
Yes, if there's a violation based on not meeting specific license conditions, our CNP, which is our Conservation and Protection Unit, would be responsible for reviewing that violation and pursuing it pursuant to the penal provisions under the Fisheries Act. That would not be licensing's responsibility.
Thank you. Mr. Lunn, if I could please go to number 53 on the exhibit list. Is that right? Am I right that that's what this is? This is the 1994 Commercial Licensing Handbook?
Yes.
I'd ask this be marked as an exhibit, please.
Exhibit 583.
This dates to 1994 and provides some very basic information about the licensing program or process really for the Pacific Coast. Is there, and I'll ask this, I'll turn to the next document first. Number 54 on the Commission's list of exhibits is entitled a draft. At least it's stamped as being a draft as a commercial licensing policy review, or the Commercial Licensing Policy Handbook from 2008. Do you recognize that document?
I do.
What is that document? Is it an update of the document I just showed you from 1994?
This is an updated version based on the changes that have taken place with licensing practices and rules since the time of the original document. So this one has not been published or made available to the public.
All right. I'd ask this be marked, please, Mr. Registrar, as the next exhibit, the 2008 document.
584.
Thank you. And it says, I think your answer, as well as the big stamp of draft, tell us this is not a final document. What is the status of this document, to your understanding?
It's still being worked on. There's a review taking place of current licensing rules and practices, and the intent is to, if there's any changes made, to update this handbook and make it available to the public to have an understanding of all of Pacific Region's licensing policies.
And to pick up on that comment, there are two documents I'll show you that really go in sequence. The May 2010 is the date of this document, Pacific Region Licensing Rules Options for Change discussion paper. There's also a September version of this paper. Could you first confirm that this is a document that describes, does that describe part of the review process that you were mentioning?
Yes, it does. It's a discussion paper that is in draft form that's intended to be sent out to license holders and vessel owners to consider some possible proposals for change to licensing rules.
And I'd ask that this number 55 from May 2010 be marked as an exhibit, please.
Exhibit 585.
And if I could then go to the next number on the list, number 56, because it looks very similar. I don't know that this version is in ringtail at this point or not. I don't know that I have a number for it. But this is seems to be basically the same document, but September 2010?
Yes, this is a draft that's been updated after further review and provided to senior management for consideration of release.
And if I might ask that this be marked as the next exhibit, number 56 from the list.
Excuse me, 586.
Why don't I try to work from the number 56 on the list and ask you a few questions about that. And indeed, to do it, I'll ask to turn to page 2 of this document. This comes from an internal review of licensing rules, I understand, from 2008-2009, to look at modernizing the rules, to look at reducing the level of complexity and dealing with different requirements and obligations. Is that fair?
That sounds reasonable, yeah.
And looking at the first full paragraph, as a result of the review, the Pacific Fishery License Unit has proceeded with amendments to administrative processes for vessel registration and salmon stacking applications. Effective September 1, 2010, the application to register a new commercial fishing vessel will no longer require the submission of a survey done in accordance with DFO vessel measurement guidelines. That's a change that's taken place?
This hasn't been implemented yet. It was proposed to be, but because this version was not approved, we haven't implemented those two options.
That's helpful. And what is that's at this point still under consideration, is that right?
Yes.
I take it the idea there is simply to take away the requirement that the commercial vessel itself, the application of a new vessel requires that the vessel owner provide a survey to document its, I suppose, its length primarily.
Right. As I mentioned before, with salmon licenses, they have a length restriction where the vessel has to, in order for the license to be issued, the vessel has to meet a certain overall length. The department keeps track of those overall lengths based on vessel survey reports that fishermen have marine surveyors do and submit to the department so that we can keep record. At this point, we pretty much have records of all the overall lengths for the majority of the boats, unless it's a new boat. So this particular recommendation is to get out of that business and to use Transport Canada's overall length that are on record with their registry for new boats.
Right. The next full paragraph, in addition, stacking of commercial salmon licenses is now permitted at any time during the licensing year. What's the status of that?
There's still a stacking application, except commercial salmon category A licenses are not are limited to applying for stacking during the salmon season.
Mm-hmm.
So there's a deadline for submission of application before the salmon season. The intent was to remove that restriction and allow for stacking any time during the year, which some other category licenses are currently permitted to do.
There's a mention of a number of options that are under consideration. I won't review those in any detail. They're set out in this document. But if we then flip ahead to about page 6, I think in fact page 7 of this document has a feedback questionnaire. And I take it the aim was, as you've said, to have a discussion paper to send it out along with the questionnaire to invite those within an interest in this to provide their input that way. Is that right?
Right. It would be part of the consultation so that we could take a collaborative approach, collate the feedback that we get back from vessel owners and license holders, and then have further discussions through our consultative process with advisory boards and all the affected fleets to discuss the results.
And that document has not been, or sorry, that process has not taken place yet?
It has not started yet, no.
Is there a timeline, or do you have an expectation of when that may occur?
No, I don't, because it'll be subject to approval of release of this document and then the consultation plan that would proceed as a result of that.
If I might turn to number 57 from the Commission's list. And the question here, the broader question is to get an understanding of the guidance that is given to the licensing unit staff in particular. Am I right to say that this, at the upper left of the document, it says PFLU, Pacific Fisheries Licensing Unit Manual Salmon Category A for 2010-2011? Is that what this is really, is a manual or a guidance documents for staff?
Yes, it's an amalgamation of the information on how license officers, what they should be aware of, what are the licensing requirements, what is the current management plan for the salmon fishery, the steps that they would go through in order to issue the license.
If I could ask this be marked as the next exhibit, please.
Exhibit 587.
And indeed, without going into detail, there's points in this document where it actually has a checklist for the staff member to check the boxes and ensure that all the steps have been taken. Is that right?
Right. It's very important that license officers don't make errors with respect to issuing licenses.
Stepping back from this document, what happens in a situation where the a license, a commercial salmon license, is not renewed in a given year, where this person or the vessel registrant simply does not show up to seek renewal of the license, does it lapse?
Well, the vessel would still hold that license eligibility, and what we would do is the licensing unit would proceed to send a letter to the vessel owner advising that they hadn't met the requirement by the appropriate deadline and that their eligibility may lapse should we not receive the appropriate fee for that year. Should they not respond, they will then be sent another letter advising them that their eligibility is lapsing, and they will have to go to the Pacific Region License Appeal Board for consideration for issuance of that license so that the minister could consider it.
In practice, does that situation happen, or are people
It happens very
diligent in
rarely.
general in renewing their licenses?
Most fishermen are very diligent about applying for their license regardless of whether they're going to participate in the fishery or not.
And I appreciate there's no rule of automatic, no entitlement for automatic renewal of the license, but again, in practice, is it fair to say the license holder who's coming back to seek renewal of the license it wouldn't be turned down?
That's right, provided that he met all the licensing requirements, the license would be issued. Sometimes there's unique circumstances where there's change in ownership of the vessel, or the vessel's a total loss, or some circumstances happen and it may hold up issuance of the license until other requirements are met. There are licenses that we relinquish through the allocation transfer program or through PIG fee program, Pacific Integrated Commercial Fisheries Initiative, where these licenses will create a party ID in our licensing system, and these licenses upon relinquishment will be placed into or issued by that party ID, which is our inventory, and then upon redistribution of those licenses to eligible First Nations, they will then be issued to the First Nations party ID and no longer be an inventory. But after the year is over, those licenses will then go back into inventory and possibly be redistributed in a different fashion the following year.
And I wonder if I might go to tab 58, number 58 on the list of exhibits, and picking up on that point. This is a memorandum to the Regional Director General from 2009. Has to do with the department's unallocated commercial salmon licenses. I'll simply read to you from the point in the summary box, but not the handwritten point. The department's inventory of unallocated salmon licenses has increased to 156 commercial licenses distributed across all 8 commercial salmon fleets as a result of ongoing departmental programs to buy back licenses. In recent years, the department has used licenses and inventory to provide commercial fishery access to First Nations via demonstration fisheries. For 2009, as in recent years, a key priority for unallocated licenses will be to provide commercial access to First Nations for demonstration fisheries in inland areas. Any remaining unallocated licenses would be available to provide individual commercial licenses to coastal First Nations under the Allocation Transfer Program, ATP, to address specific needs for additional commercial salmon shares in priority areas, for example, Cowichan, Goldstream, or Lower Fraser, or could remain unused. Could you comment on how this process works and whether this is an accurate description of it?
I haven't seen this briefing note. It looks like a draft and an old one from 2009. I believe this describes process with respect to the licenses that are issued to First Nations on the interior demo fisheries, which currently is approximately 197 licenses, so it's changed a bit from the number that's in here.
Sure.
As far as the process goes, I'm not an expert, or my area is not with respect to administering the process for ATP or PIG fee. I don't work in either of those two areas, so I could only give you a very broad perspective on how this process takes place.
That's fine, and I won't be heading into that. And although this looks like a draft because there's handwriting, I won't ask you to play handwriting expert, but that may in fact be Ms. Farlinger's handwriting on the 4th page of the document. It is signed by her, so it may look like a draft, but I understand this to be a final document. Despite the limited evidence the witness had on this, I would ask this be marked as an exhibit, please.
Exhibit 588.
Mr. Commissioner, with respect to our timing this morning, it's about 10 minutes before 11. I'm content to continue, or I don't know if the preference is that we take...
Please continue.
Thank you. I'll do that, and perhaps we'll aim for the regular break time of about 11:15. With respect to a different topic, I have a question or two about area reselections. And I take it that term of an area reselection refers to a situation where the department on an occasion-by-occasion basis may allow license holders to effectively play musical chairs or switch to a different area, albeit one within the same gear type that they already have a license for. So a gillnet license holder, for example, might have an opportunity to reselect to a different area. Is that an accurate, albeit simple way to understand what reselection is?
All salmon licenses have permanent gear selection, and they also have had to elect an area as of the Mifflin plan back in 1996. There were a number, I guess 3 times since then, that vessel owners have been given the opportunity to elect a different area, so they would submit an application for area reselection within a certain time frame. Those applications would have been mailed to them by the licensing unit, received and verified, and it's possible that a number of licenses have changed areas since the original selections. The last one that we did, I believe, was 2007, 2006, 2007, which is up for review in 2012 for the possibility through consultations with the salmon industry for another option for area reselection.
And I don't have it at my fingertips, but I think the PPR makes reference to the 2007 election reselection remaining in effect. But I take it, just so I'm clear about the status of this, in 2007 there was an opportunity for people to reselect. At the conclusion of that, they're now stuck, or at least there's no opportunity for people to reselect. There may be one in 2012, or it'll be considered at that point.
There is an opportunity for licenses to change areas through the stacking application process, where vessel owners can stack 2 licenses together to have the option to fish a combination of gear and areas, and then the license that is being stacked can be applied for an area change at that time, and also some flexibility in an increase in length as well. Other than that, there is no other opportunity that I'm aware of for reselecting areas.
And just to understand a little more about reselections, let me go to number 62 on the exhibit list. And this, for the benefit of participants, the initial document I think had some personal information about a license holder. We've since been provided a different version that takes that information out of the 2nd or 3rd page of the document. So I expect Mr. Lunn has that version. Just to move through this fairly quickly, the first page from March 13, 2007 is the stamp on it. That's the covering letter that would have gone out to vessel owners or license eligibility holders describing the area reselection process. Is that correct?
Yes.
And unless other council or the commission has a different view, I'll move through all of these and be suggesting they become marked as one exhibit. The next page, because they really do fit together, the next page is the application for an area reselection, an area selection.
Yes.
The following page is general information. There's a summary, about 4 or 5 pages in the salmon area summary of process, and then an FAQ, or frequently asked questions description. In this case, the FAQ is specifically to the troll area selection. Is that correct?
Yes. This was because trolls had salmon troll licenses had a different time frame in order to apply for an area reselection.
And I'll ask that this be marked as an exhibit, please.
Exhibit 589.
And I'll, by way of introducing this, just to narrate on the record, I'll be picking up on the points that are in the bullet points there, but it's helpful to have the whole paragraph 14 before us, because the origin of some of these suggestions is the 2005 Pacific Fisheries Reform Initiative. And related to that, it stated there, the announcement followed reports from the Joint Federal and Provincial Task Group on Post-Treaty Fisheries, which is the Treaties in Transition report, and the First Nations Panel on Fisheries, Our Place at the Table, which is also an exhibit in these proceedings. I should also just state that Exhibit 14, which is the summary of past reports and recommendations, well, I won't go to it, but the reference there is page 231, which goes to the Pearson-McRae Treaties in Transition paper. So all of that is a very long-winded way of introducing the few points I have to ask you about. The first recommendation that was proposed, that's set out there, the first bullet point, extending commercial licenses for longer terms, even as long as 25 years. What I'll ask you to do is please comment on both the merits and the status of those proposals.
My understanding of this proposal is to provide longer-term security and stability to those that participate in the fishery by allowing them a privilege that provides a longer-term access to the fishery that they participate in. Currently, our practice is to issue annual licenses because under the Fisheries Act and the regulations, the minister does have the authority to issue up to 9-year licenses, actually. There's a term up to 9 years. However, all of the license fees would have to be collected up front. We don't have the authority to take installment payments from eligible license holders or vessel owners without a regulation change, which we have been looking into nationally. The department is considering ways of doing that. So whether it's practical to have a 25-year license at this point for vessels that have, regardless of the fee, for any fisherman that participates in a fishery, in some quota fisheries, their fees can be as high as $10,000, $20,000. They would have to pay all of this fee up front. So in that sense, it's not practical, which is one of the reasons why there hasn't been a lot of movement on this. There's been suggestions to use 5-year licenses, or at least something that provides a longer term stability for access to the resource. And like I say, we have been looking into ways to do that.
So the upfront payment is a real problem with moving to that sort of a model. It could be out of reach for vessel operators.
Right, and I think that's something that is just within our current restrictions that people don't quite understand. So it might look as a good option on face value of it, but when it actually comes to implementing it, it's not going to be very practical. We also have some other restrictions on us where we can't receive. For example, we allow fishermen to pay with credit card, but we can only take up to payments up to just under $5,000, $4,999. So as you can see, if you had to pay more than that, I don't know how practical it would be to pay these kind of license fees. So it is something that we're limited to. That like I say, we're looking into how we would provide that flexibility and change our regulations accordingly.
I take it part of the rationale behind that sort of a longer-term license would be that it theoretically would give a commercial vessel operator some sort of an asset that they could borrow against, for example, or take a loan against the fact that they have a license that's 25 years in length, that it gives them some stability or security. But in practice, you're often, in your various roles, you've dealt often with license holders. Is that been expressed to you as a point of concern, that people are unhappy they can't borrow against their license, for example?
It depends on the situation. Where a lot of licenses, they're owned, there's partnership arrangements or arrangements with fish companies. There's can be often a number of vessel owners involved with a particular license. Generally, also they participate in other fisheries, so they may have access to quota, or they may have access to participate in other fisheries, which increases the value of their fishing operation. So it really depends on their fishing operation. I know that there are some fisheries that have moved, for example, to permanent quota, like groundfish fisheries, where there is a lot of interest from the participants to move to party-based licenses and longer-term licenses, to considering that they have permanent quotas that they reallocate between licenses. So it provides for that ability to, you know, secure more funding for quota to be considered something similar to property in their minds. The department still considers licenses a privilege, though. They're not a right or property, but obviously for a lot of fishermen there's a value in the license and quotas associated with it. So.
Let me ask you about the second bullet there. Considering a shift to personal rather than vessel licenses, especially where individual quotas are implemented. Again, asking the question if you could please comment on the merits, and perhaps the easier first question is the status of that. I take it that shift has not happened.
It hasn't happened in the salmon fishery, but our current licensing structure is different for every fishery, and there are a number of fisheries that are participants hold party-based licenses as opposed to vessel-based licenses. And there is this current climate to move to party-based licensing for everything. It's something that the department could do. Basically, it means instead of the vessel holding the license, the individual or company holds the license, similar to communal commercial licenses or category N licenses in the salmon fishery, where the flexibility that it would provide is instead of being attached to the vessel, which can restrict you, you would be able to designate whatever vessel you want. There may still be some length restrictions and some other policies around it, but it would provide a little more flexibility, and also that sense of it's conducive to like a quota managed fishery, where it gives you what you were mentioning earlier, some permanency or some sense of holding something as an individual or company, as opposed to it having to be attached to a vessel that once that vessel something happens to it or it's transferred or whatever, you wouldn't have access to it. So
Do you think it would be a good thing to move to personal or party-based licensing, or are there reasons to stay with the vessel-based system?
it's something we certainly could do, but we would have to look at the impacts, and we would have to look at, implementing it in a fair fashion where we're considering all of the fleets and all of those fisheries that are vessel-based, and look at what that would then mean to the licensing structure, but it's definitely doable.
I'm going to be brave and skip over the ITQ point and go to the fourth one. Ensuring transferability of licenses so that old fishers could retire and young fishers could enter the business. Could you comment on, that's a broad type of recommendation of something that should be on the agenda. Could you comment on that, please?
Well, we have transferability in the majority of the fisheries, whether it's in vessel-based fisheries, they would apply to do a permanent replacement. So a new owner can then hold the license that's attached to that vessel by doing the replacement. Party-based, we have what we call a nomination process, which is basically transferability, where it can be the license holder would elect to nominate someone else in their place to hold the license. So this particular recommendation has pretty much already been adopted by the department, except the exceptions are spawn on kelp and clam fisheries.
And I take it in terms of any demographic issues with the age of commercial fishers, are those issues that there's nothing specific in licensing that needs to change to address that? That may be a problem, but there's no obvious solution in license reform?
No, if an application is made to retiring from the fleet and or new entrants coming in is whoever's then going to own the boat. If a vessel replacement is done, that's how the transaction takes place. And now you've got a new entrant into the fishery to replace the old one. You just don't have new licenses. Same with nomination. If it's a party-based license, someone else is just taking the place of the existing license holder in a limited fishery as well. So I'm not sure if I answered your question there.
That's helpful, thank you. I'd like to ask you some question next about license buybacks and relinquishments.
I wonder, just before you go there, if I could just ask the witness, on that. Yeah, it's on. I might just move it closer. Ask the witness a question. Paragraph 14 that's on the screen in front of you, witness, refers to April 2005 and a management initiative, a reform initiative called Pacific Fisheries Reform. I don't think we need the document brought up on the screen. It is an exhibit. And then Mr. Martland just took you through those bullets, or some of the bullets, under 14. I just want to get clarification. Perhaps we can bring that document up, Mr. Lund. It's the Pacific Fisheries Reform Exhibit number. I'm not sure. There it is. That document is entitled a discussion paper on the implementation of Pacific Fisheries Reform. Is that the document you're referring to, or is being referred to in paragraph 14?
That is the document they're referring to, as well as the Pierce-McRae Report, Treaties in Transition. Yeah.
I'm taking a literal interpretation of a discussion paper on the implementation of Pacific Fisheries Reform. So to me, a discussion paper means just that. It's a document which is circulated for discussion purposes.
Right.
Am I correct in that understanding?
Yes, and what the reflection of that, the points that they made, are some of the objectives and general principles that are a part of this discussion paper.
So those bullets that Mr. Martin took you to are part of that discussion?
Correct.
Okay. What's confusing me is paragraph 15, the next paragraph in the PPR.
Right.
I don't understand what that means.
What it means is a lot of our current programs and policies are guided by Pacific Fisheries Reform principles. We currently operate under what we call Pacific Fisheries Renewal, which adopts a lot of these similar principles. It's mentioned in that discussion paper that you brought up earlier, a lot of the guiding principles about consistency, transparency in our rules, providing stability, looking at opportunities for fishermen to self-adjust, be more self-reliant, for more economically prosperous fisheries.
Right.
And so fisheries reform feeds into a lot of that, our current initiatives, that pick fee, for example, and other initiatives. That's the linkage to Pacific Fisheries Reform, but it is an old document, 2005.
So the bullets that Mr. Martland took you to, if I understand your evidence correctly, are simply considerations. They are not policies that have been adopted by the DFO.
Right. They're things for us to consider for future licensing policy and practices. They were recommendations, basically, from the treaties in transition that they tied into, feeded nicely in their perspective with Pacific Fisheries Reform. And I think that's why the connection. That's the way I look at it. But so in terms of whether we've had to adopt these four principles, or these four, whatever you want to call them, considerations, the department would look at that with respect to the current circumstances of each fishery and its sustainability requirements, and looking at a consistent approach to apply to all fisheries.
All right, just so I'm up to date then, we have the April 2005 document. Is there something more recent that reflects upon the bullets that are set out in paragraph 14?
I haven't seen any recent documents that have these four specific recommendations or principles in them. It's been replaced, like I say, by other documents that we may have on our website when we refer to fisheries renewal, or a lot of the principles that we use in the pig fee program.
I'm just trying to get a complete understanding of what the current status is of the activities of the DFO around, for example, these items that are listed in paragraph 14.
Right. The first one we haven't been able to make much progress on, but are considering. The second one has already taken place in a number of fisheries, but not with respect to salmon. The third one, as you probably heard through the last few months, there's a number of initiatives around managing fisheries through share-based management, moving away from competitive fisheries into having a share-based management approach, and individual quotas and pooling arrangements, for example, is used in the herring fishery. IQs are used in groundfish and a number of other fisheries, and on a pilot basis in the salmon fishery for those involved in demonstration. And then the last one, I believe we've already pretty much have this in effect under our current practices and policies and licensing. It just has not been extended to every fishery. That's how I'd look at it.
Thank you very much.
With respect to license buybacks and license relinquishment, and we won't go into great detail on the history of the different programs, but I think it may be helpful to ask you for a general understanding of the main initiatives that the department has had. I take it mainly aimed at reducing the size of the commercial fleet in the province, and in some of the cases, that sort of a policy direction or a decision to try to reduce the capacity of a fleet is done in part through licenses, and by setting up a situation where there's simply less license, the capacity is reduced because there are less licenses being fished, being actively used. Could you help us to understand the main license buyback programs that have been put in place, let's say from about 1994 onwards?
Well, there's the 1996 Mifflin Plan, voluntary salmon license fleet reduction, where vessel owners would apply voluntarily to retire their license. The objective of the department was to see a immediate decrease in the number of licenses in the salmon fishery. In 1998, to pursue some of our conservation objectives and to adjust the fishery to be more in line with the declining salmon stocks and opportunities. We also had the Canadian Fisheries Adjustment and Restructuring Program in 1998, which also a large element of that was a certain amount of money that was set aside specifically to retire and again reduce the fleet with the objective of up to half of the licenses, again to meet the objectives of reducing the capacity so that there was a better economic opportunity for those that were remaining in the fishery and to provide fishermen with an opportunity to retire or to get out of the fishery. Those were the two main retirement programs, meaning that the licenses were permanently retired and not issued again in any fashion. So the capacity was removed from the fleet permanently.
And are there other types of initiative where it's not a retirement per se, but rather a notionally a redirection of the fishing effort to another part or another sector or another
right.
Group of people? And if you could describe that, please.
We refer to those as license relinquishment programs. Two of the current ones that are mentioned in here that you're aware of are the allocation transfer program and the pick fee program, where the objective of the department is to increase participation by First Nations in integrated fisheries, so not just salmon, all fisheries, by relinquishing licenses and or quota and redistributing that access and those allocations to First Nations.
Just so I'm clear on the terminology, you've referred to license retirement as being the sort of reducing the capacity of the fleet, as license relinquishment in the context of things like pick fee, where it's not a question of reducing the number of licenses, but making use of that fishing power in a different way, or reallocating.
Right. It's a transfer of the access.
And then how does the term license buyback, does it cover both of those other categories, or is that a different?
Yeah, industry uses the term license buyback to basically refer to, and the department's used it too. Buyback is just a way of saying retirement and or relinquishment. It's a way of saying the department is offering based on a specific payment to receive a license and relinquish. There's a relinquishment agreement associated with it where the fishermen would apply and relinquish all rights and everything that's associated with that license. So they're both, in that sense, in the term buyback. You could refer to either one. Most people just use that term. They don't make the distinction.
Mr. Commissioner, I know at the time, I wonder if we might take the break.
Thank you very much.
Hearing will now recess for 15 minutes.